Hello everyone, this is Advocate Dr. Sheetal Babar, and today we shall be discussing and furthering towards our next doctrine under Transfer of Property Act, which is Doctrine of Priority. It is also called or nomenclated as Rule of Priority. Now there comes a situation where there is one owner who transfers his property, same property, to many in many different transactions. So the question always arises as to who is the first claimant or who is the claimant who have priority over all other transferees. To get this answer, we have section 48 under Transfer of Property Act, which deals up with number of transferees and one transferor. However, to understand what exactly has been mentioned and discussed under section 48, let us go through the wordings of this section. Section 48 of Transfer of Property Act states, where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights cannot all exist or be exercised to the full extent together, each later created right shall, in the absence of a special contract or reservations binding the earlier transferees, be subject to the rights previously created. So, before discussing this, let us just have what all the elements or ingredients of section 48 in before you. The first ingredient is there has to be one owner of the property or transferor, one transferor, while there ought to be number of transferees. So the term transferor is singular, while the essential is the number of transferee ought to be plural. Secondly, section 48 specifies that it is only applicable to immovable property, and hence the property in question should be immovable property. Thirdly, it should be transferred at different times, and at these different times there ought to be rights created in transferee. However, all of these rights cannot be exercised to the fullest at the same time. These are the essentials under section 48. Now, talking about section 48, this basically is something which is derived or based on a maxim which states qui prior est tempore, prior est jouer. Means the one who comes first in time is better in law. So the one, here time is the requisite. However, we don't apply this doctrine literally, because the one who comes in time appropriately should be actually an add-on to this maxim. Why appropriately? Because let us take certain examples to explain this particular point. Let us take two illustrations of the same transaction. First, UA is owner of an immovable property called A. He transfers this immovable property A by oral contract to Bhaji in the month of July. The same property is transferred by UV to Sachi by oral contract in the month of August of the same year. So here we have all the requisites sufficed. First, there should be one transferor, UV is the transferor. There ought to be same immovable property in various transactions. So here A is that immovable property which is in question. There ought to be plural transferees. So Bhaji and Sachi are two different transferees. The property ought to be transferred at different point of time. Here one transaction concerned to that property has happened in the month of July and another happened in August in the same year. So these are two different transactions of the same immovable property by same owner or transferor to different transferees. Now applying this doctrine of qui prior est tempore, prior est jouer. In this transaction, we say time is the only context. Both of the properties are transferred by oral transfers, and hence it is the one who comes in time first will be better in law. And here Bhaji, who is in time first, because in the month of July of the same year, we say Bhaji has all his rights in priority compared to Sachi. Same transaction happens with a little bit of twist. Yui transfers his property A, immovable property A, to Bhaji in the month of July, orally. Subsequently, Yui transferred his immovable property A to Sachi, while Sachi is more legally aware and he insisted upon registration of the deed. On this insistence, Yui registered a deed of this transfer in the month of August concerned to Sachi. Now we have same illustration with a twist, which is registration of the document in subsequent transfer. And hence I say, when we discuss this magazine which says qui prior est tempore prior est jouer, needs an add-on of appropriate, because here Sachi is more appropriately or legally strong compared to the earlier transferee, and that is what an exception to section 48 is, subject to special contract or reservations. Here, due to registration of a transfer deed by Sachi, Sachi holds all of those legal rights. Why? Because the first earlier transfer or transferee, that is Bhaji, had made only oral contract. Hence we say the one who is in time appropriately shall be the one who is better in law. However, when it comes to same immovable property, same owner but different types of transactions, then section 48 will not be made applicable or cannot be taken into consideration. How? Let me explain. Let us take an illustration where Yui is owner of immovable property A. He transfers this property A to Bhaji by lease. So Bhaji here is a tenant in the month of July. In the month of August, the same property is transferred to Sachi by mortgage. And then the same property is gifted in the month of September to Stevie. In all of these three transactions, if we see, transaction is concerned to the same immovable property, that is A, by the same owner, or rather owner of the property, that is Yui. But these three transferees are in different positions. One is the tenant, another is a mortgagee, and thirdly the one who is receiver of the property as a gift. So here these three doesn't stand in the same position, and hence we say section 48 is not to be made applicable in the situations. While we take again an illustration with a twist, same illustration with a twist. Here we say Yui transferred his property A to Bhaji by lease. In next transaction, he transfers his property A to Sachi by mortgage. Subsequently, he transfers his property, same property A, to Stevie by mortgage. And fourthly, he transfers the same property A to Ani by gift. So there are 4 transactions of same property. Now let us consider whether section 48 is made applicable in this scenario. And if yes, to who all of amongst these transferees. Now one specific rule to make section 48 applicable, or principle to make this doctrine or rule applicable, is there has to be the same denominations concerned to the transferees if they are in the same transaction with the same denominations, then we say section 48 is applicable. That means they all should stand in the same position as being the transferees. When I mean to say denominations, in our illustration, all of these four, let's see if they are in the same position or denominations. The first, that is Bhaji, is a tenant. So he stands in one position. Second is Sachi, he is a mortgagee. Third transaction is with Stevie, he also is a mortgagee. And fourthly, the transaction with Ani is the gift of that particular property. So he is in a totally different denomination. But then in this situation, there are two transferees who stand in the same denominations or stand in the same position. It is Sachi and it is Stevie. So here we make the principle or the maxim which states as to quid prior est tempore prior est tuer. Sachi stands in time first, while Stevie stands second in time, and hence better in law is Sachi. So basically this is all about what and how this doctrine of priority is to be made applicable in what all situations. So this concern to section 48, doctrine of priority or rule of priority from my side is all. Thank you so much.